All righty, there is so much conflicting testimony in this case, isn't it? And you guys buzzing on our social media accounts, I'd love to hear it. So keep tweeting us and get on Facebook. A lot of you are saying there's just too much doubt for a murder conviction. Okay, for a second-degree murder conviction, right? What about manslaughter or even a lesser charge than that? We have hit pause, by the way. You aren't missing anything. Nothing's happening in court at the moment, so we can have this discussion. But, you know, David Otunga with us now. And I know the defense could rest its case today. But we're assuming it could certainly happen. Do you think either camp could ask for a lesser sentence here, other than second-degree manslaughter? Or second-degree murder? Could it go down to manslaughter?
You see, the state could call what's called a charging conference, and they could ask for manslaughter, which would be a second lesser-included offense. However, the defense would likely ask for no lessers. Now, the judge is most likely going to deny this, but let's think about this. If she granted this, that would mean that it's either second-degree murder or acquittal. And I'm going to tell you right now, it's looking like it's going to be pretty tough to get that second-degree murder charge. But it's ultimately up to the judge to decide which charges will be included and which one she brings to the jury.
Sure. Jane, what do you have to say to that?
Well, I guess that it's anybody's guess at this point what these possible lesser includeds would be, but I can tell you that the blogosphere is debating it, and I just got something from a lawyer who was talking about all sorts of possible lesser includeds, and it goes to aggravated battery, aggravated assault, felony battery, culpable negligence battery. I mean, the list goes on and on. So this is very speculative at this point. As the attorney just said, it's really going to be determined in the charging conference, and when they decide what those lesser includeds will be, if there will be any, then we'll have a better idea of what the playing field is and what these jurors are going to have to consider. And I will say another thing. These jury instructions, trial after trial, I have seen it, they're long and they're complicated, and the more lesser includeds are included, the more complicated it gets, and it can be mind-boggling for some of these jurors to wade through all that.
Yeah, Jason, Dr. Jason Johnson here with us, too. I'm wondering if you do start adding more and more lessers, do you think that's really that much better for the prosecution, or would that manslaughter, because some people are saying, well, I don't know, manslaughter seems to maybe have a much better chance here than anything else?
I think what's going to happen is the prosecution's going to look at what their close is going to be, and that's going to determine which of these lesser charges they want. I think it's interesting. Detective Serino, even though he says he was pressured, he suggested manslaughter. Manslaughter is the one that basically argues it wasn't your intention, it wasn't premeditated, but you set up circumstances, you got out of the car, you set up circumstances that resulted in somebody dying. So I think that's the main thing the prosecution would go for.
And Jason, you make a great point that Serino suggested those manslaughter charges, and he suggested them because he said in his police report in March, this encounter was ultimately avoidable if Zimmerman would have stayed in the car. And my question to you is, do you think that that merits Zimmerman getting on the stand and explaining why did you get out of the car?
That's definitely a question I want answered, and that's the first one I would ask him if he gets on the stand, but
too much room for...
I have to tell you, yeah, I don't know if it's worth it at this point to get Zimmerman up on the stand.
But
if
to
I was
avoid a
his defense
manslaughter
attorney,
charge?
Look, if I'm a juror, I got to hear from this guy. That's what, and if he does not get on stage and explain himself or on the witness stand, I'm going to question it. Because if your story is, I'm a regular guy and some random kid, you know, hopped up on Skittles and iced tea attacked me, I want to hear you tell me that story. And if he doesn't, I would question it as a juror.
I do have to point this out from the defense's perspective.
I disagree 100% respectfully. I mean,
Go ahead,
look,
Jane.
Jodi Arias was on the stand for 18 days. What happened to her? Guilty. Casey Anthony
that's who I
sat there
thought
with
of.
her Mona Lisa smile for the whole time. What was the outcome? Acquitted. We have already seen his side of the story in the reenactment video, in the interviews he gave to law enforcement. He's been able to tell his story 6 ways to Sunday. It's his version of events that has dominated these proceedings, and I think that's tragic in the sense that we aren't, in my opinion, getting a clear-cut version of what happened, at least the prosecutor's version from the prosecution. We're getting a bunch of scenarios.
Yeah, and a lot of people, I think, are looking at this jury thinking they're going to go into that room with so many questions that will probably never get answered, and what does that mean at the end of the day? Well, let's take a look at, I want to hit play for you again and get you right back to the courtroom with Dennis Root. He's a use of force specialist.